Unit 8 is all about contracts, and the idea of contracts kind of coming late in the class is it's meant to be what I refer to as a transactional approach. It's meant to be an approach to the overall transaction sort of in a logical order. Because if you think about the class, now that we're deep enough into the class, you kind of have some perspective on this. We started with the idea of basically what is a real estate agent? What is a licensee? That's kind of like who needs a real estate license? And then we moved from there into, what is real estate itself? What does it mean when we talk about real estate as a topic? What is land? What is realty? What are fixtures? What are appurtenances? And then we talk about the restrictions on land and all those kinds of things. And then we move into agency. And agency is how you might be hired to represent somebody. So if you think of this transactionally, you understand real estate now. Now you understand how you might be hired to represent somebody in that transaction. Now, we've also talked about finance. So you've talked about like, okay, somebody hired you to represent them like a buyer. Now you have learned about finance and maybe walking them through the finance process and talking to them about getting pre-qualified. And so now you've got some knowledge that you could share with them about the qualification process and what kind of loan they're going to be looking for. Next up would be making an offer. Next up in the transaction. So if you think about like a buyer, the whole transaction, well, you got to understand real estate. That's step one. And then you got to understand how they can hire you. That's step two. So let's assume now that they've signed that buyer agency agreement. They've hired us to represent them in the transaction. And then you've talked to them about financing. Maybe you've gotten them in touch with the lender. Maybe they've gotten pre-qualified for, I don't know, let's say they're going to do a conventional loan, a conventional insured loan. What would that instantly tell you about the kind of loan they were doing? If they're doing conventional insured, what kind of loan would that tell you that they were doing?
Fixed rate.
Over 80%.
Over 80% loan to value, right? They're not putting down 20%, right? Because if they were putting down 20%, it would be uninsured.
Uninsured.
Right? If they're putting down 20%, there would be an uninsured conventional loan, but it's insured. So what else do we know about it? What's the most important thing when I say conventional? What's the definitional thing of conventional? It should pop to mind first. It often doesn't, but it should. What's the definition of conventional loan?
Not government insured?
There you go. Has nothing to do with the government. Conventional loans have nothing to do with the government and government backing or government insurance. Very good. Very good, right? So if we've gotten them pre-qualified for that conventional uninsured loan, now we've gone out and we've looked for houses for them and we're ready to make an offer. That's kind of where we are transactionally. We've progressed all the way up to the point, and I see Elizabeth clapping over there, right? We're ready to go. We're ready to make an offer. And that's when we got to understand contract law. Does that kind of make sense to everybody, how we're doing like building blocks and working our way up? And not surprisingly, guess what's going to come pretty quickly after we go through the contract section? We're going to move right into closing the transaction. And that's exactly right. We're getting closer and closer to the money in this thing. We're getting closer and closer to finally getting paid. And so, we're getting closer to the end of the class because we're getting closer to the end of the transaction as well. Because it really is a transaction is a process, just like getting licensed is a process. The transaction itself is a process. So section 1 or unit 8.1 deals with those very basic things of contract formation. What is a contract? What is, what does a contract mean? Because that's a word that we throw around a lot. That's a topic that gets overly utilized a lot. And people use the word, but they don't know what it really means. I find that so often to be true. People use the word contract, but they don't know what it really means to be under contract. They don't know what a contract really is. They don't really have any concept. So the definition of a contract is pretty straightforward, but there's more there than meets the eye. It says a legally enforceable set of promises between legally competent parties. Here's the word we've got to focus on: promises. A contract is a set of promises between two parties. It could be one promise. It could be 10 promises. It could be one side promising to do something. It could be both sides promising to do something for each other. But always at the end of the day, it's a set of promises. Does that make sense for everybody so far? Like the whole idea of, but the problem with promises is promises get broken all the time. Unfortunately, people promise things and then don't follow through with them. Promise is not strong enough on its own. And that's where you get to this phrase, a legally enforceable promise or legally enforceable set of promises. I'll take you to the prom. Is that a promise? It is.
Yes.
Can one person sue the other if they don't take each other to the prom, even though they said they would take each other to the prom?
No, it's just a
No.
promise.
Not unless you have it in writing.
Right, exactly, because it's a promise, but it's not a legally enforceable promise. Does everybody see the difference there?
Yeah.
A contract is a promise taken to a whole nother step, a whole other level. A contract is a set of promises that said, I promise this to you, but I don't trust you. Because the truth is, if you trusted somebody, you wouldn't require them to sign a what?
Promissory
Contract.
note.
A contract. There's no reason for them to sign a contract if you trust that they will do what they say they're going to do. That's one of the most inherent things to understand. This is why lawyers are so cynical, because they deal in contracts all the time, which means they literally, the name of their profession is distrust in people. That's the whole reason the law is a profession, because people can't trust each other. That's the whole reason we have contract law, is that people can't trust each other. It's a really cynical outlook, and I don't mean it to be a downer in that regard, but I think it's imperative for you to understand why contracts exist. Here's what I mean by that. Folks, stop and drop this naive viewpoint that people can just change their mind when they're under contract. You can change your mind about who you go to the prom with. You made a promise, but there's no legal ramifications to breaking that promise. There might be personal hurt feelings, but at the end of the day, the other person can't do anything to you because you don't go to the prom with them, correct?
Mhm.
But if you violate a contract, are there going to be legal ramifications, legal repercussions?
Yeah.
And that's what makes it a unique sort of agreement. A contract takes this so much further. This is legally binding on these parties that they do what they promised they would do. So that kind of just hopefully gets you in the right mindset. The contract itself, and we're going to be specifically talking about sales contracts here, is what we're going to be focusing on. The sales contract is all of the promises in total that have been made between these two parties. It should be the entirety of the agreement. It is the agreement in full. But look at that last statement. It should be enforceable in a court of law. And I'm going to highlight this last phrase, if needed. Where do we hope contracts never end up, folks?
In the court.
Or law.
In court. The last place we want a contract to end up in is in court, because here's what that means. Inevitably, if a contract ends up in court, it means one of the two parties feels that the other has breached that contract. One of the two parties to that promise feels that the other one has not lived up to their promise, and they're going to court asking for relief. They're going to court saying, no. We had this in writing. We had this as an agreement. We have this as an enforceable agreement. And we're asking you as the court system to force this person to do what they promised they would do in this agreement. That's what a contract's all about. But we want to avoid court if at all cost, if we possibly can, because it's just an ugly, ugly process. But that phrase, you're going to see it over and over and over. Legally enforceable. Is this agreement enforceable legally? Now, what's our role here? Our role is to provide advice in a transaction. To whom? What people do we give advice to?
Client.
Client.
Clients. Because advice is part of old car, and we only owe that to our clients. Do we give? Let me phrase the question this way. Can I help a customer with a contract?
Yes.
You could, yeah.
Absolutely. Absolutely, I can help a customer. Am I going to advise them about
No.
that contract?
No.
No.
No. Can I help a buyer? If I'm the seller's agent, I'm the listing agent. Can I help a buyer fill out an offer to purchase contract on my listing?
Yes.
Yes.
Yes. And I don't represent that buyer. I represent the seller. So the buyer's my customer. I can help them. I want to be clear about that. Can we help people without representing them?
Yes.
Yes.
Right. But that's not the people we're going to give contract advice to. The people we're going to give contract advice to, and here's how you know you're giving contract advice. If you're explaining the contract to somebody, if you're saying to the person, the purchase price is the amount of money that you're willing to pay for the property. Is that help or is that advice?
Advice.
What do y'all think? Help or advice? The purchase price is the amount of money you're willing. And this is what I'm saying to this person. The purchase price is the amount of money that you're willing to pay for the property. Is that help or is that
That's
advice?
help.
That's help.
Help.
That's just
Help.
help.
You're
I
explaining
am
it.
literally explaining the facts to them. Does everybody see that?
Yeah.
Mm-hmm.
The purchase price is how much you're willing to pay the seller for this property. And I think you should probably offer something like $425,000.
Now you
Is
went
that
to
help
advice.
or is that advice?
Advice.
Advice.
That's advice. Does everybody see how the difference between dealing with a client and a customer when it comes to contracts?
Mhm.
Right? Customers, just the facts. Here's what this is. Here's what this line is for. What do you want on this line? Clients, here's what this is. Here's what this line is for. And here's what I think you should put on the line. That's the difference.
Mhm.
That being said, you're going to see a test question about something, and I just realized the slide needs to be adjusted here. This next bullet point, it says the licensee is not an attorney, unless you are an attorney, in which case this doesn't apply to you. But if you're not an attorney, and I'm assuming most of you are not, you should never write the language of a contract. The language is all the pre-printed stuff. When you look at a pre-printed contract and it's 12 pages, all those words that are on there, guess who wrote those words?
An attorney.
Lawyer.
An attorney did. And so guess who you have to be to make changes to those for your clients or customers?
An attorney.
Attorney.
An attorney, right? Now, that is different. Are those pre-printed contracts going to have fill in the blanks on? Are they going to have blanks that are meant to be filled in?
Yes.
Yes.
Yes. Can we give advice? Can we fill in the blanks and give advice about what should be filled in the blanks there to our clients? What do y'all think?
Yeah.
Yes.
Yes.
For sure. That's our job. What's not our job is to go in there and say, oh, we don't like this paragraph, so we're just going to, we're just going to take this paragraph. That's not our job.
Mhm.
If they want that to happen, they should go talk to who?
An attorney.
An
An
attorney.
attorney. Now, I want you to add this to your slide because I'm going to add it here. For our clients or customers. Because there's actually a potential gotcha question on the test that you need to be aware of. There is a time when licensees can make changes on contracts. There is a time. How about if the licensee is the buyer? How about if the licensee is the seller? How about if they're not doing this for a client? Can people make changes on their own contracts?
Mhm.
Yes.
Yes. And we are people too. So there's a gotcha test question. That's why I want you to add. Does everybody see why I want you to add that phrase right there? So let me give you an example. Let's say Howard is a buyer's agent and he's helping that buyer make an offer on a property. And the buyer says to Howard, you know what, this paragraph down here where it says this earnest money deposit thing is going to be due within 5 days of us going under contract. I don't know if I can get it to them within 5 days. Won't you cross out 5 days there and put 10 days, Howard? Just cross out 5 days and put 10 days. Can Howard make that change for his buyer client?
No.
No.
No, he's not an attorney. That's a legal function. Does that make sense for everybody?
Mhm.
Yes.
Now, practical question. When Howard says to the buyer, I'm sorry, I can't do that for you. I'm not an attorney, and that's a legal function. The buyer says, well, just give me the pen. You give me the pen then, and I'll cross it out. Can the buyer themselves cross it out and make that change legally on that document?
Yes.
Yes.
Yes, it's their contract, folks. They can make, that's no different than them representing themselves in court. You always have the option of representing yourself in court. It might not be smart. You might lose, but you have the right to legally represent yourself. Does everybody see the difference there?
Mhm.
Okay. Now, I'm going to give it to you again. We're going to stick with this same example because you need to see how this is going to change depending on the, nuance here. So here's how the conversation goes. The buyer says to Howard, Howard, I don't like 5 days. I want you to cross it out and put 10 days. And Howard says, I'm sorry, I can't make that change for you. I'm not an attorney. And the buyer says, well, just give me the pen. Just give me the pen then. I'll do it. Are we okay so far?
Mhm.
Yes.
Yeah. So Howard hands the pen over to the buyer. And the buyer, right before they cross it out, looks at Howard and goes, do you think 10 days is good or should I put 12?
No.
Mm-mm. Mm-mm. That's
No.
advice.
Can't advise him.
Not only can Howard not make the change, Howard can't give them advice about a change they should make to that language. Does that make sense for everybody?
Mhm.
Yes.
Because again, he's not a what?
Attorney.
Not an attorney. They're not asking him for transaction advice. They're asking him for legal advice, and he's not qualified to give legal advice. Does that help everybody kind of get it in your brain, like what can and can't be done in that situation?
Yes.
Yes.
Okay. So here's the situation. Rachel is functioning as her own buyer's agent. And she and her husband are out looking at property, and she's the buyer's agent for herself. Everybody with me so far?
Yeah.
And she's looking at making the offer, and she thinks to herself, 5 days to turn in the earnest money. That's kind of quick. I wish it was 10 days. And so she takes the pen, and she's a licensee now. She's got a real estate license. And she crosses out 5 days and put 10 days on there. Has she violated license law?
No.
No.
No, because she's not functioning as the agent when she makes that change. She is the what?
Buyer.
The buyer.
She's the buyer. Does that make sense for everybody?
Travis, I have a quick question.
Okay, go ahead, Taj.
If I cross it out and say 10 days, no, I want 10 days as a buyer, and the contract is legally enforceable, is the judge, if it ever got to court, would the judge side with me because I said 10 days?
I'm not sure what your question. I'm not sure what your question is.
Because I didn't take it to an attorney. So so the seller didn't agree with it.
Well, first of all, if the seller didn't agree, it's not a contract. Part of a contract is both sides have to agree. So if you were to make that change, guess who it would have to go back to be signed off on? The seller would have to, right? And so if the seller never agreed to that change, a judge would say, this was never agreed to. So
they can cross it out all they want to.
Cross it all you want to, but the other side's got to agree. But now, if both sides agree to that and it ended up in court, most likely the judge would go with the 10 days because it would be clear intent by both parties to agree to 10 days. And there's nothing wrong with a buyer or a seller or a tenant or a landlord making changes on their own agreements like that. Don't tell them, because I think sometimes the reaction is to say, no, 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 you can't change that. No, that can never be changed. This is like the sacred scrolls that came down from Mount Sinai. You can't change it. Yes, we can't change them for a client or customer, but can they change them for themselves if they want to?
Yeah.
But here's what I would caution you against. I would say, and I would give this advice to anybody at that point in time. However, Taj, you're not an attorney either. So be very careful about what changes you make, because there may be unintended consequences that you're not thinking of. Is that possible that a buyer or seller who doesn't know the law could be making a change that they think helps them, but actually hurts them in the transaction?
Yeah.
Yeah, for sure.
So the best advice, even though they can make the change, is always, why don't we have you consult an attorney here and get their advice on this change that you want to make and see how that, because the problem with contracts and making changes is there's a lot of things in contracts that refer back to like a previous paragraph. And I've seen this happen where somebody's like, I don't like this paragraph, and they just cross out that paragraph. Well, then there are 5 other paragraphs in the contract later on that refer back to paragraph 13, which you crossed out. And if that ends up in court, the judge is going to say, well, you didn't just cross out paragraph 13, you crossed out all of these paragraphs because they all refer back to what?
13.
Paragraph 13.
And the buyer might say, well, I didn't mean to do that, but too damn late now. You know, y'all agreed to it. And that's the danger of them making their own changes. Are we all, is that all okay for everybody? I will point out one sort of gotcha they could throw at you about that on the test is listing agreements or buyer agency agreements. Folks, aren't we a party to the listing agreement or a buyer agency agreement? If we're filling one out and signing one on behalf of our firm, aren't we a party to that agreement?
Yes.
Yes. So what if you got a test question that said Elizabeth is a listing agent and she's filling out the standard exclusive right to sell listing form from the North Carolina Association of Realtors, and she decides to cross out paragraph 12 and insert, her own statement in place of that paragraph? Has she violated license law? What do y'all think?
No.
Yeah.
She has not violated license law. You got to ask yourself, who is a party to that agreement? If it's a listing agreement, isn't Elizabeth a party to the listing agreement? Who signs the listing agreement? It's going to be signed by Elizabeth and the seller, right?
Yeah.
And if Elizabeth is the one signing it on behalf of her firm, can she make changes to that document? She sure can. So that's the way you're going to answer that question. You're going to visualize in your head, okay, what document are they talking about? Does the agent sign this document, or does the client sign this document? If the agent signs the document, can the agent make changes on it? Yes. If it's only clients or customers that are going to sign the document, can the agent make any changes to the document?
No.
Does everybody see the difference there? Okay.
So agents don't sign the contract, just their information is on the bottom.
That's exactly right. The sales contract is never, you're never going to see a signature of a licensee on there unless the licensee is the buyer or the seller on a sales contract. They'll be mentioned on the very last page, who's the agent representing the buyer, who's the agent representing the seller, but they don't sign it. They're not a party to the agreement. Okay, good. So I choose to think of contracts almost like marriage, which for some of you might be a wonderful reference, and some of you may be like, oh, really? Your mileage may vary on that. But I think it is something that we can all relate to, because one of the things that I find that people make mistakes about is just getting their mind in the wrong place when it comes to contracts. People confuse the contract and the closing. Folks, they are 2 entirely different things. Yes, you need a contract to get to a closing, but the contract is the promises the closing is fulfilling those promises. Does that make sense for everybody? But before we even get to a contract, we have to have a proposal, right? Before you get to, yes, I'll marry you, somebody's got to ask, will you marry me? The proposal, guess what we're going to call that in contract terminology?
An offer. The offer.
Offer. That's exactly right. The proposal, the will you marry me, is an offer. I mean, because isn't that what's happening? One side is basically saying, I'm willing to be bound by this agreement to you. Are you willing to also be bound by this agreement to me? Doesn't that sound a lot like an offer and a transaction?
Yeah.
Right now, at this point in time, and this is why I think the analogy works really well. At this point in time, is she free to say, I don't want to be bound by this contract?
Yes.
Yes.
Yes. And at this point in time, is he free to, even as she is like gasping and her face lights up and she's about to say yes, but she hasn't said it yet. Is he free to get cold feet and snap that box closed and be like, oh no, I can't do this. I can't do this. I rescind my offer. Is he free to do that?
Yes.
Yes.
Yes. As ugly as that would be, that can happen because neither of these parties have made promises to each other yet. Does that make sense for everybody? We're in the offer phase. So how do we apply that to a contract question? When can an offer be rescinded by the one making the offer? When can the one who's holding this box, the guy who's holding the box here, when can he rescind that offer?
Anytime.
Before they sign the contract.
Before signing it.
Anytime before she says what?
I do.
Yes. Anytime before she says yes. Not I do. Because I do is the closing further down the road, right? Right? Anytime before she says yes, because the moment she says yes and they become engaged, they are under contract. They have made promises to each other. Does that make sense for everybody?
Yeah.
And if you think about it, aren't there going to be, listen, there would be repercussions to him rescinding this offer, but it would be far less than the repercussions of him breaching this contract. Wouldn't it be far worse if she said yes and they go and they get engaged and they send the engagement announcements out and she orders invitations and she goes and buys a dress and they got they've reserved the venue and then he breaches the contract? Wouldn't it be far worse to happen later? And that's the other thing you find with contracts. And that's why I love this analogy for contracts. The further you go down the road toward closing, the later you breach, the worse the consequences are, right? This gets worse every day you get toward closing because people start to bank on, yes, this is going to happen. Yes, this is going to happen. Yes. And you just rip it right out from under them. It gets worse and worse and worse. Does that make sense for everybody? Okay. So if the proposal is an offer, the yes is the acceptance. That's a word we're going to deal with a lot in the next few hours. Acceptance. What does this word acceptance mean right here? Acceptance means both parties have now agreed to be locked together with each other. Acceptance means that it's not one-sided any longer, that both parties have considered this arrangement and both parties have come to an agreement that this arrangement makes sense for them. Is everybody okay with that? So when we're engaged, we're essentially under contract. We've made promises to each other, but those promises have not yet been fulfilled, right? And just like a contract, is there going to be some work that needs to be done before we can finally fulfill fulfill the promises of the contract? Do we have to make arrangements for closing, which in this case is going to be the marriage, right? We got to book the venue and we got to figure out where we're going to get married. We got to get the marriage license and we got to go and, all of those things have, well, think about a contract, folks. Once we go under contract, doesn't that trigger a lot of things that the buyer is going to need to have accomplished before they're ready to close? And not just the buyer. Doesn't that trigger a lot of things that the seller is going to need to have accomplished before they get ready to close? They got to make arrangements to get moved out of the house. They got to make arrangements to fix anything that they've agreed to fix. They've got to make arrangements to have utilities disconnected and cancel insurance. This is a process once we go under contract. And if you think about it, like in terms of the engagement, you don't book the reception hall before she says yes. And so let me put that in terms of a contract. Could you, well, let me ask you this. Could you book the reception hall before she said yes?
You could.
You
Yeah.
could. But would you be taking a major chance that she would say no and you'd lose your deposit and you're never even engaged and now you got a reception hall?
Mm-hmm.
Yes.
So here's a practical question with a contract. Could a buyer do inspections and appraisals and all those things before they even make an offer?
Yes.
Yes.
Yes. But wouldn't they be taking a major chance that the seller never even accepted their offer and they've spent all this money and this time and this energy doing inspections and appraisals on a house they can't even get under contract on?
Mm-hmm.
Mm-hmm.
So that yes moment usually triggers the start of all of these preparations. How we feel so far? Is that kind of clicking for you into gear, how this works?
Mhm.
Okay. And then of course we need a closing. And the closing is the big moment. The closing is the moment where all those promises are fulfilled, where what we promised to do for each other has finally come to fruition. And the truth is, we don't know what looks like behind that closing. I think we like to tell ourselves that every closing has been picture perfect. Folks, is there any guarantee that that buyer and that seller actually fulfilled all their promises? Or do all we know is that they just said, okay, you've done enough, we're done, we're closed? What do y'all think?
Just said they were going to do it.
And they've done enough to close, right?
Mhm.
For all we know, the seller could have promised to replace the deck and never did it.
What's enough?
But and that's who decides it's enough. Well, the buyer decided it was enough because guess what they did anyway?
They closed.
They closed. And so let's tie that back to the marriage analogy. We don't know that he hasn't cheated on her since they got engaged. Maybe she knows that he cheated on her since they got engaged. But did she accept that and decide to close anyway?
Yep.
Yeah.
Yes. So the parties to the contract, folks, don't think of contracts in such absolute terms. Remember, the contract is not there to force the parties to do exactly what they promised. The contract is there to provide legal repercussions if they don't, and if the other party wants to force the matter. If we get to closing, and this is why I go down this road with you mentally. If we get to closing and the seller promised to replace the deck and they haven't done so, if the buyer closes, can they come sue the seller after the fact because the seller didn't replace the deck?
No.
No. Because here's what a judge would say. You accepted that. If that was a problem for you, you should not have what?
Closed.
Mary.
Have closed. You shouldn't have accepted the deed. You shouldn't have recorded the deed. You shouldn't have paid them for the property. This is like crying over spilt milk. Get out of my face. Case dismissed. So, practical application. You're the buyer's agent. Day of closing. Now, keep in mind, they got all the stuff on a U-Haul truck. They're ready to move in. And you go do that final walkthrough and the seller has not completed some repair. What choices does the buyer have? They can either accept it as it is and close, or they can not close. Because the only way they can actually exercise their legal rights is to not close. They have to go to a court and say, wait a minute, Your Honor, the reason we're not closed is they haven't lived up to their end of the bargain. As soon as they live up to their end of the bargain, we'll close. Is that a good argument to make to a judge, by the way, if you're the
Yes.
buyer in that situation?
Yes.
Mhm.
Yeah, you go stand in front of the judge and you say, listen, I'm ready to close, but you can't expect me to close. I'm not going to do what I promised to do until they do what they promised. If they replace the deck, I'll close. What do you think the judge is going to issue an order to do?
Replace the deck.
Replace the deck. Replace the deck. And that's what contracts are about. It's about providing that legal sort of avenue for relief. Okay, how we feel so far? Are we all okay with where we're headed here and what a contract is, the purpose of the contract?
Yes, and question, Travis. So let's say the buyer agrees everything, they change the deck, everything goes good, and all you have to do is close, and then the buyer doesn't close.
Well, then if the buyer doesn't close, then who has legal remedies now?
Seller.
The seller does. And then it's up to the seller to decide if they want to exercise their legal remedies. And here's the other truth. Sometimes people just throw their hands up at it and say, I don't want to deal with all that. Is it a pain in the rear end to have to go sue somebody?
Yes.
Yes.
Of
Oh, yeah,
course.
for sure.
Are there going to be instances where sellers, think about the current market, okay? Let's say you've got a buyer who promised to buy your house and you had 25 offers and you get to the day of closing and the buyer won't close. Is the seller going to be upset?
Yes.
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 Absolutely.
Now, do they have legal recourse of going and suing that buyer and trying to get the court to force the buyer to close, right?
Okay. Yes.
Mhm.
Is everybody with me?
Yes.
Mhm.
Sure. But they also have a house that they got 25 offers on. Might the
Right.
seller just go the hell with it, put it back on the market and sell it to somebody? I ain't got time for all this in my
It
life.
wouldn't make any sense to spend all that money and time to go.
There you go. And there you go. Just
Okay.
because somebody has the legal right to enforce a contract doesn't necessarily mean that they will. We've all heard this expression and we just laugh it off. But here, how many of you have heard this expression before? So sue me. When somebody thinks you've done the wrong thing, what's the expression we throw out there when somebody says, you can't do that? And you
Sue
look
me.
at them and you go, so sue me. And
Okay.
guess what? Almost nobody ever does. Sues,
Sue.
because it's a pain to do it. And so the reality is contracts just set up the framework that allows somebody to sue. That's what a contract is there for, is to set up the set the scene, set the rules so that both parties have the right to sue each other if things don't go as planned. Just because they have the right doesn't mean they will, though. It's a really good question. Real good question. How we feel? Good?
Good. That makes
Good,
sense. Yeah.
good. So contracts are going to come in a lot of different statuses. And the first status that we want to talk about is, do we have an express contract? And express does not mean fast in this case. Express means I'm expressing things now. I'm talking. That's an expression of things, right? If I write something down, is that an expression of my ideas?
Yeah.
Right? So express simply means a contract that has been clearly stated. Here's what express looks like. I'm mad. You don't have to worry if I'm mad because I just what?
You just said it.
Told me.
I told you. Now, did I have to put that in writing or did I express it adequately verbally?
You
said it
expressed
verbally.
Verbally.
Verbally. So don't associate express as meaning written. Can express also mean oral?
Yes.
Yes.
Yes. Implied is this, and I'm gonna have to stop the share so you can see me big enough. Have I said anything about my emotional state?
You're mad.
No.
No, but I'm what?
You're
mad.
you're implying it. You're
I'm
implying
mad. I'm implying that I'm mad. You have gathered that I'm mad based on my actions, not based on what I said or wrote. Does that make sense for everybody?
Mhm.
And so contracts can work that way. If people undertake actions that make it appear like they have a contract, a lot of times a court will say, you have a contract, whether you ever signed one, whether you ever talked about it or not, you have a contract with each other. Let me give you a good example. Let's say you go eat dinner at a restaurant. When you sit down to order your meal, now maybe you've had this experience, I have not. Okay. Does the server say, now, Patty, you understand if you order the ribeye, you're going to have to pay us $49.95 plus tax and gratuity. And that's also served a la carte. So you'll have to order any sides you want. And those will be additional charges. Are you okay with those terms and conditions, Patty? Is that a conversation y'all have when you order a
No.
steak?
No.
No. When Patty orders a steak, they say, how you want it cooked, right? Here's the thing. Patty could get up and run out, and she might go to court and make the legal argument. I never promised to pay for that steak. I never agreed. We never expressed a contract. And would she be right? They never expressed a contract, right?
Right.
But do they have a contract?
Yes.
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 Implied.
Because here's what the judge would say. Patty's actions implied that she understood she was going to be bound by this agreement. Does that make sense for everybody? That her actions implied that she's willing to pay for the steak. She looked at a menu that had a price on it. She ordered from the menu that had a price on it. She never questioned whether or not she was going to have to pay for it. So it's implied that she understands she's going to have to do it. Does that make sense for everybody?
Mhm.
And so but now let me throw this question out there for you. Are implied contracts inherently sort of, oops, let me go back here, dangerous?
Yes, because they can be interpreted different ways.
Absolutely.
Your word
if
against
you're-
mine.
They're
if you're-
subjective. Yeah.
If you're relying on an implied contract, you're relying on the fact that both parties imply the same things from the contract, correct?
Mm-hmm.
And so there's danger in implied contract. Do you think implied contracts is the way to go with real estate transactions?
Not at all.
No.
No.
No. We don't want anything implied. And so let me give you an example of this, because you'll see this on the test. What do you think implied agency is? Implied agency.
I think that you're their buyer or seller.
You act like you're somebody's agent, even though they never hired you, right?
Mm-hmm.
You act as if you're somebody's agent, even though they never hired you. So let's say that TT goes out and puts a listing sign in front of her best friend's house because she knows the best friend's about to put the house on the market. And she knows, this is my friend, she's going to hire me. So she just goes ahead and puts the sign out there before she has a listing agreement. Does she have an agency relationship with that person, folks?
No.
Not yet.
Yes, she does. She has an ugly one. She has a what?
Implied.
She has an implied agency agreement. And here's why the courts would say she has an implied agency agreement. Is it reasonable that everybody else in the public would think TT was that seller's agent?
Yep.
Yeah.
Yeah, because she's got her sign out there in the front yard. And so other members of the public are going to contact TT about that property. And if she hasn't never actually been hired with a written agreement, she has an implied agency agreement. And guess where that gets you as far as the North Carolina Real Estate Commission is concerned?
Nowhere.
Out without a license, right? Implied agency is a really ugly thing. Don't ever represent somebody unless they've actually hired you. Now, with sellers, that means they can only hire us how? In what?
Writing.
In writing. With buyers, can we have oral express buyer agency? Can we be hired verbally by buyers?
Yes.
Yeah, before.
For a limited time,
Uh-huh.
right? For a limited time. But it still has to be expressed. You still have to have a conversation with them about, are you interested in me being your buyer's agent? Don't just start showing them houses, because that would be what kind of agency?
Implied.
Implied. If you just put them in your car and start showing them houses, you've implied that you're their agent. But if you say to them, now, we can start looking at properties, I would be functioning as your buyer's agent. Are you okay with that? We don't have to have a written agreement. We can do it verbally. Are you okay with me functioning as your buyer's agent? And they say, sure, that sounds good. That's express oral buyer agency. Does everybody see the difference there?
Mhm.
Mhm.
Okay. Good. So, like we said, express ideas or express agreements are based on the statements made, whether verbal or written. Obviously, written is preferable, whereas the implied ones are based on our actions. Some agreements are required to be in writing by a law called the North Carolina Statute of Frauds. The North Carolina Statute of Frauds requires some agreements, not all. Notice I keep very carefully saying what?
All.
What, some
Yeah.
agreements are required to be in writing by the North Carolina Statute of Frauds. Do you think there might be a test question that you get on this thing that pops up? It says, you know, with an answer choice, it says all agreements must be in writing. Do you think that might happen?
Yep.
Yeah.
Mhm.
Yes. And is that correct?
No.
No.
It is not. There is no requirement that all agreements be in writing. There is a requirement that some agreements be in writing in North Carolina. Not all, some. Okay. And that is the statute of frauds. So basically, the statute of frauds is a list of certain types of legal agreements that are required by law to be in writing if you want a court to do anything about them. If you want, in other words, this is the court's way of saying you can't have this type of agreement for certain things. You can't have a verbal agreement for certain things. So let me ask, let's see if this is starting to click into place with this law here for you. I got a quick question that can see if it's starting to click in place. And it's okay if it's not, but I want to see where you are. Are buyer agency agreements in North Carolina covered by the statute of frauds?
No.
No.
No, because we know that buyer agency agreements can be what for a limited amount of time?
Oral.
They can be oral. Are listing agreements in North Carolina covered by the statute of frauds?
Yes.
Yes.
Yes, because in order for you to have a valid listing agreement by law, it must be in what?
Right.
In writing. Does everybody see what this law is actually saying? It's just saying, here are the agreements that must be in writing. These agreements are too important to rely on verbal agreement. These must be in writing if you want a court to actually look at them and act on them. Everybody with me on that?
Yep.
Okay. And so what we're basically going to talk about over and over and over with the statute of frauds is this agreement covered by the statute of frauds? Let me give you one that we've talked about before and see what you think about it. A deed. Do you think deeds are covered by the statute of frauds in North Carolina?
Yes.
Yes.
Yes. I think it's reasonable to say we're not going to honor anybody's deed if they show up to the courthouse and just verbally say, I now own the property at 114 Heidinger Drive, right? Can you imagine if you were able to just walk in the courthouse and be like, it's mine, I own it. No, they're going to say, where's your deed? I'm like, I just gave it to you. I told you, I own it. You can't have a verbal deed. It's got to be in what?
Writing.
Writing.
Writing. But here's why it's important to understand why we need this law. Not all agreements are covered by the statute of frauds. Like we just talked about one, buyer agency, which is actually allowed to be what?
Oral.
Oral for some time. I'll give you another that people are shocked by. You ready to be shocked by one that's not covered by the statute of frauds? Leases. In the state of North Carolina, leases are not a covered document under the statute of frauds. So now apply that. Leases can be what?
Oral.
They can be oral. You can actually go to court in North Carolina and make a winning argument to a judge. We had a lease, Your Honor. And the judge is, of course, going to say, well, where is it? Can I see a copy of it? And the person goes, oh, no, we never put it on paper. We just talked about it. And the judge, if they believe you, can actually uphold that lease, even though it was never put into writing. And the reason they can uphold that lease is because it's not covered by the statute of frauds. Everybody see that? Does that make sense? Okay. So from now on, if I tell you a document is covered by the statute of frauds, you're going to immediately know a judge would not respond to that agreement unless it was what?
In writing.
In writing.
In writing.
So now, real estate sales contracts, contracts to sell real estate, agreements to purchase real estate, however you want to phrase that, are covered by the statute of frauds, meaning you don't have a contract to sell that house unless you have it in what?
Writing.
In writing. No court in North Carolina is going to agree that you have a purchase agreement in place for a piece of real estate unless you have that agreement in writing. And the reason is they're not allowed to. So let me ask, now I want you to practically apply it. You play the judge. Michelle walks into court and she is suing Kayla. You just happen to be side by side on my screen. So that's how, sorry, Kayla, you know. So Michelle is suing Kayla. Michelle claims that Kayla agreed to sell 30 acres of land to her in Wilson County for $200,000. Everybody following me so far?
Yeah.
That's Michelle's claim. She's suing in court because she's claiming, Your Honor, Kayla promised to sell me this 30 acres of land for $200,000. Everybody with me so far?
Mhm.
Mhm.
Okay. The judge is going to say, where's the agreement? And Michelle's going to say, well, Your Honor, I've set up a TV over here because what I did when I met with Kayla, because I know you can't trust Kayla, I know how she is. I set up 25 high-speed, high-definition 8K video cameras and 18 microphones to record our conversations from all different directions. And here's the whole interaction. Here it is in slow motion when we shook on it. Here's the whole thing. Here's the, she agreed to sell it to me. We got it from every different angle. You can see the pimples that she doesn't even have. That's how good this video is. Do we have a contract, folks?
No.
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 No, it doesn't matter how compelling Michelle's evidence is. The judge is not even allowed to entertain it because that agreement is covered by what law?
Statute of Fraud.
The
Any
statute of
fraud.
frauds. The statute of frauds. Now, don't go too far in the other direction. Does in writing literally mean any form of writing?
Yes.
Yes.
So here's
One
my
of them.
question. What's better evidence of a real estate sales contract in North Carolina? Michelle's 32 angles of video or something scribbled on the back of a cocktail napkin that says, I agree to sell my 20 acres to you for $200,000 and Kayla signs it?
Put them
Cocktail
like,
napkin.
Napkin.
The cocktail napkin is
It's
better
on there.
evidence.
So if you have a friend that promises to sell you their house, you should just put something in writing before the contract gets written.
That's exactly right. Put it in writing. Put it in writing because that's the only proof that a North Carolina court is allowed to entertain about a real estate sales contract. But how about a lease? If Michelle went to court and said, Your Honor, Kayla promised to lease me this 30 acres of land and she's got her video evidence, who's going to win?
So the-
use with.
Michelle in that video.
Michelle.
Michelle in the video is going to win for a lease. Does everybody see the different treatment there? And it's all because that lease is not covered by the statute of frauds and because that sales contract is covered by the statute of frauds. What we're trying to say here is judges don't have latitude to choose, what evidence they follow. The type of agreement makes the choice for them. Does that help everybody now?
Mhm.
Okay. So the statute of frauds says that certain agreements must be in writing in order to be enforceable. Implied agreements happen, like we said, when the parties never really came to an agreement, but their actions dictate. I still love the most classic, in my opinion, example of an implied agreement, but increasingly it doesn't work as an analogy in class. I'm still going to say it because it will entertain some of you who are chronologically challenged as I am. Some of you will remember pulling up to a gas station, getting out of your vehicle and just turning on the pump and filling your car up with gas. No credit card, no payment. You just turned the pump on and you filled the car up with gas. And then after you filled the car up with gas, you were expected to do what?
Pay.
Go in and pay.
Expected to walk inside and pay. That is a very classic example of an implied contract. Here's how you know it's an implied contract. If you don't go inside and pay, will there be legal repercussions?
Yes.
Yeah.
Absolutely, there will be. And that's implied. Your actions pumping the gas implied you were willing to pay for it. Does that make sense for everybody?
Mhm.
Uh-huh.
Okay, good. I'm sure some of you are like, they used to do what? They just like trusted you. And yeah, and so here's what it became for those of you who did not live in such a glorious time. Here's what it became. you had to know the people who owned the service station. You would pull up at the pump and you would flip the thing on and it would tell them inside the service station that you were trying to get gas, but they had to press a button for the pump to work. And you would just not wave at them and okay, I know him. And they'd turn the pump on for you and you would pump your gas and then you'd go inside and pay.
Can you say one more thing about implied for me? When we were talking about person putting the sign on the lawn, right? That's a binding implied contract?
Well, binding is going to be up to the judge. Binding is going to be up to the discretion of the judge. Here's what the judge would likely say. It'd probably be binding on the listing firm. The listing firm would probably be held to all the standards of listing that property, but without any compensation, because they implied to the public that they were willing to. So in other words, and I think it was TT we talked about who put the sign up in front of the best friend's house, right? So let's say that a buyer contacted TT and said, oh, I'd like to see that property. And then TT contacts the seller and the seller says, I never hired you. TT's going to have a problem because now TT can't fulfill the obligation she has because she implied to the public she could do that. Does that make sense for everybody? And so she could be sued at that point by both the buyer and the seller. The buyer could sue them for wasting their time. Well, I mean, I was trying to look at the house and this person, the only reason I called this person and spent a day trying to arrange a showing with her is she put a sign out there. She implied she was the listing agent. And the seller could sue her saying, I never hired this person. And she's out here implying that she represents me to people. That's crazy. Would she probably lose both of those lawsuits? She would be. And that's what I mean about being held responsible for that implied contract. Does that help? Basically, you are holding yourself out to the public to be something you're not when we're talking about implied agency. And that's why it's such a mistake. To go back to, now this is not different from, and this is where we have to really kind of get in the right groove of thinking here. This is not going to be different from express or implied. Contracts have about 6 different statuses all at one time. So now we've moved past, okay, is it an express contract or is it an implied contract? And we're moving to the next phase. This is in addition to, not other than. Does everybody see the difference there? So now we've decided this is an express agreement. We want to decide, is it a bilateral express agreement or a unilateral express agreement? So we're just adding on more definition to this contract. We're giving it a more well-rounded definition here. Contracts can be either bilateral or unilateral based on how many of the parties have made promises. Now, let me tell you where you're going to get confused with bilateral and unilateral on the test. Somebody, and I don't know who it's going to be, but somebody on a test is going to answer that a unilateral contract is a contract with one party. Folks, there are activities that you can engage in with yourself. A contract is not one of them. There is no such thing as a contract of one person. A unilateral contract is not a contract with one party. All contracts have what?
2 or more.
2 parties.
Multiple.
Right? All contracts from our perspective are going to have 2 parties. Bilateral contracts have 2 parties. Unilateral contract. In fact, that's why I've given you this little visual right here, right? Look at both of them. If you just look at the picture, they look exactly the what?
The same.
The same. So it's not the number of parties that are different. It's the number of promises. Look at the promises under these here. Let's talk about the bilateral one first, right? Party number 1, they what? They will. I promise I will do something. Everybody with me on that? Party number 2, I what?
May.
I will.
May.
Bilateral. I what?
I will.
I will.
I will. Both parties have said they will what? They will do something. The promises go in both directions at the same time. That's a bilateral contract. A unilateral contract is one party is saying they what?
They will.
They will, while the other is saying they what?
May.
They may. This is a contract that the promise only goes in one direction. A unilateral contract is an agreement between two parties, but only one of them has absolutely promised that they will do something. How do we all feel about that? Okay. Bilateral contract is a contract where the promises go in both directions. A unilateral contract is a contract where the promise only flows in one direction. So I want to give you some examples and we'll talk about it. When it's bilateral, I want you to think of a handshake. Both parties have shook hands. They have shook on it and they've said, I promise I'll do this for you. Think of your normal lease. That's a good example of a bilateral contract. Has the landlord promised they will do something?
Mm-hmm.
Yes.
They've promised they will provide the property for at least a certain amount of time, correct?
Yes.
And probably also promised that they will maintain the property and done some other things. There are promises the landlord has made to the tenant. Everybody agree with that?
Mm-hmm.
Yes.
Are there promises the tenant has made to the landlord?
Yes.
Yes.
Yes, pay the rent.
Pay
Okay.
rent,
They will pay the rent.
not destroy the property. There's promises that are made by the tenant. So
Mhm.
they have exchanged promises with each other. That's a bilateral agreement.
Mhm.
Everybody with me on that?
Uh-huh.
Okay. Unilateral, and I find that people don't have a hard time understanding bilateral agreements, but unilateral agreements often create indigestion for people.
Mhm.
Unilateral agreements often, people have a hard time recognizing a unilateral agreement. I've given you an example here. If you cut my grass, I'll pay you $50. Now, the person who wants their grass cut has made a promise. I will what?
Pay you $50.
Cut your grass.
I'll pay you $50. But has the other person promised anything?
No.
No.
No, the other person hasn't said, I will cut your grass. The other person hasn't contracted or promised to cut the grass. This is an open-ended sort of, if you do this for me, I will do this for you. And the other party's not saying, okay, I will cut your grass. They're just going, okay, I'm cool with those terms. Because here's the thing, does the other party have the option of sleeping in tomorrow and not cutting any grass?
Yeah.
They do. They do. And does the owner of the property have the ability to force them to come cut the grass? Can the owner of the property go sue them and Judge Judy gonna say, you promised to cut their grass? They're gonna say, no, I didn't. I never promised to cut their grass. They told me they'd pay me $50 if I did cut their grass. But I'm gonna be honest, I was hungover. I was not in the mood to go be cutting any grass that day. And so I didn't cut the grass. Well, they never promised. Does everybody see that?
Mm-hmm.
That's a unilateral promise. It's completely one-sided. Now, look at this one and tell me what you think. Carl owns a home in Mebane and has signed a purchase agreement promising to sell the home to buyer Cassie for $350,000. Cassie has promised to close on the home at that price no later than July 15th of 2022. Is this a unilateral agreement or is this a bilateral agreement?
Bilateral.
Bilateral.
This is a bilateral agreement. And here's how the way I work that out. I always love to make little notes for myself when I'm answering these questions. Here's what I do. I put Carl on one side and Cassie on the other. And I say, okay, Carl owns a home in his Mebane, has signed a purchase agreement promising. So there's his promise. Does that make sense for everybody?
Mm-hmm.
Yep.
Promising to sell the home to buyer Cassie. Cassie has promised to close on the home at that price no later than July 25th. Well, folks, which way are the promises going?
Both ways.
Both ways. That's a bilateral agreement. Does that make sense for everybody?
Mhm.
Yes.
And here's what's also important to understand about that bilateral agreement. Either one of them has the right to sue if the promises are broken. If Cassie doesn't show up for closing, can Carl sue her? What do you think?
Yes.
Yes,
Yeah.
yes,
If Carl doesn't show up for closing, can Cassie sue him?
Mhm.
Yes.
Yes, because here's what happens. If Carl doesn't show up for closing, Kathy's going to sue him saying, you broke this promise right here. Does that make
Mhm.
sense for everybody?
Mhm.
mhm,
Yes.
And if Cassie doesn't show up for closing, Carl's going to sue saying, you broke this promise right here. Does that make sense for everybody?
Mhm.
Yeah.
yes,
And that's a bilateral contract. When either party has the right to sue and neither party has the right to get out, that's bilateral. So look at this one. Brenda has signed a purchase agreement as a buyer of a piece of vacant property in Orange County. The seller has agreed to sell the land to Brenda for $1,450,000 with a scheduled closing date of August 10th, 2022. Brenda has 30 days remaining in an option period that allows her to change her mind and terminate the agreement. Is this
Unilateral.
bilateral or unilateral?
Unilateral.
Unilateral.
This is unilateral. This is unilateral. This agreement right here is unilateral. And I love it when you get that right. Here's the thing. You got Brenda on one side. And you got the seller. They don't give us a name for the seller on the other side. The seller has agreed to sell. Does everybody agree that the seller has promised?
Mhm.
Yes.
And it sounds a lot like Brenda has agreed to buy, because it says Brenda has signed a purchase agreement. Okay, here's what's her promise. The seller has agreed to sell the property for $1.4 million with a scheduled closing of August 10th. Brenda has 30 days remaining in an option period that allows her to do what?
Change her mind.
Change her mind. Does that erase her promise right there, folks?
Yeah.
Yes.
Yeah, Brenda hasn't promised to do anything because she has the right to change her mind. This is a one-sided promise. This is a unilateral contract. Does that make sense for everybody?
Mhm.
Okay. Bonus points if you can tell me if this is a unilateral express agreement or a unilateral implied agreement.
Express.
Express.
Express. How do we know it's express?
Because
In
they signed
writing.
the
Right.
agreement.
They signed it. It says they signed it. So if it's written, if they signed it, it's in writing. That means express, right?
Mhm.
Okay. So this would be a unilateral express agreement. How do we all feel about that? Labeling that.
Good.
Everybody okay?
Mhm.
Okay, good. So trying to see if I could think of another example to give you. Let's say that Hilda is purchasing a new construction home. And she has signed a contract with the builder that promises to purchase the home, which is scheduled to be completed by December 31st of 2021. Everybody with me?
Mhm.
Okay. The anticipated purchase price is $380,000. However, and Hilda agrees to the $380,000. However, she also agrees that the seller has the right to change the purchase agreement to update the cost if building expenses increase between now and December 31st. Is this a bilateral agreement or a unilateral agreement?
Unilateral.
unilateral.
It's a unilateral agreement. One side has a bunch of wiggle room, right?
Mhm.
If one side, in this case, who has all the wiggle room?
The seller.
Seller, the
seller,
builder,
yeah,
right?
the builder.
Builder's got a ton of wiggle room here. That's a unilateral agreement. Because basically Hilda's promised to be along for whatever the seller decides at that point.
Mhm.
And people don't understand that, and they're doing it. How crazy is that people are doing that in this market with these builders? They're signing these contracts every day that say, oh yeah, we anticipate the sales price will be 380, but you know, these building costs are just spiraling out of control. So you agree that we'll tell you within 30 days of closing what the final purchase price is, and you agree to pay us that. They literally signing a document that says, we'll just give you any number that we pull from our air and you'll agree to it.
That's ridiculous.
It's
That
crazy.
is ridiculous.
It's crazy, and people are doing it every day. It's crazy. And it's not unusual. And shocker, on every single one that I've seen that the contract looks like that, shockingly, the price goes which way by the time they get to closing.
Well,
Oh, we had some cost overruns. Oh my gosh, we just could not have possibly anticipated. Yes, you could have. That's why you wrote the contract that way.
But really, it's because the market's going up, not even about
It is. It's because the market's going up and they're trying to anticipate the market going up. And listen, building costs are out of control and they are spiraling, and so the builders do need relief in that regard. But I just find it hilarious that these buyers are agreeing to these agreements that basically say, you know, we're giving you a number here, but it's a completely meaningless number, and you promise to pay us whatever the number happens to be by the time we get your house built. And if you, it's insanity, but it's what they're doing, and they can get away with it, you know, because buyers are willing to agree to it. Here's the thing I want you to understand. It's not that a bilateral contract is better than a unilateral contract. It's that it's more binding because it's binding on both sides. Does that make sense for everybody? Let me ask you a theoretical question. Could a unilateral contract be better in certain circumstances for certain parties?
Oh, yeah, for sure.
Yeah, if you're the one who has the wiggle room, a unilateral contract is great, isn't it?
yeah.
You know?
Yep.
I mean, if we want to go back to the marriage analogy, here's the unilateral contract. You get to the wedding, and the officiant says, you know, do you promise to love, honor, cherish, honor, you know, all that, you know, the whole, you know, riot act they read. And one person says, I do. And then the other person, do you promise to love, honor, cherish, obey? I'll think about it. Can you imagine if you saw that at a wedding? That would be a unilateral wedding, right? I'll think about it. I'll let you know.
That'd be your wedding.
Exactly. I want the unilateral variety. How do we feel about unilateral versus bilateral? Everybody, you will see that as a test question for sure. We good?
Yep, I'm good.
Good deal. Good deal. So enforceable. Enforceable is the word that we are very likely to see utilized extensively when we start dealing with contracts. Enforceable simply means that a court of law would honor this agreement. If it ended up in a court of law, we would honor the agreement. The contract would be binding for the promises that have been made. I want you to keep in mind, even a unilateral contract can be binding. It's binding on one side, whereas a bilateral contract is binding on both sides. Okay. So enforceable simply means some legal weight. Somebody could end up being sued as a result. So I'm going to kind of give you a sneak preview here because I feel like you guys are the advanced group. If I said a contract was unenforceable, what do you think that means?
Not enforced by law.
You can't force it.
You can't enforce it. You can't what?
enforce it.
Take it to
You
court.
make it. You
Can't
can't
take
take it
it
to court.
And if you did take it to court, what would the
That was
judge
a trick
do
question.
with it?
Like, you're crazy. This isn't enforceable. Like,
That's exactly
Sure.
right. You're crazy.
Here.
Get out of my face. This is unenforceable. I can't do anything with this hot garbage you have laid on my desk right here. Because that's exactly what unenforceable means. It means hot garbage. It's like there are words here on this paper, but they don't mean anything because they are what?
Unenforceable.
Unenforceable.
Enforceable.
So let's go back to a law we talked about a few minutes ago. The Statute of Frauds says that a document that's covered by the Statute of Frauds that's not in writing is what?
Unenforceable.
Enforceable.
So a verbal real estate sales contract. How would we describe a verbal real estate sales contract?
Unenforceable.
An unenforceable agreement. You might have an agreement. Y'all might have shook on it. You might have come to an agreement, but that agreement in a court of law is unenforceable. Does that make sense for everybody?
Yes.
Travis, I have a quick question. I'm trying to wrap my brain around how is a unilateral contract binding if the other person didn't necessarily promise anything?
Okay. So let's go back to the grass cutting example. It's a great question. Let's go back to the grass cutting example. Taj, I'll pay you $50 if you cut my grass. That's a unilateral contract. All right. I'm just telling you it is. I'm telling you right now it is, but we're going to talk our way through how it can be binding. You with me so far?
Yep.
Taj, I will pay you $50 if you cut my grass. Have you promised to cut the grass, Taj?
No.
No. Did I promise to pay you if you cut the grass?
Yes.
Yes. So you cut the grass and I don't pay you. Can you sue me?
Yes.
Yes. You don't cut the grass. Can I sue you?
No.
That's what a unilateral contract is. When it is enforceable on the one party who made a promise, when only one party made a promise, and that's the only party who could get sued. See, there's no way under the sun you can get sued as a result of if you cut my grass, I'll pay you $50. There's no way you can be sued. Because if you don't cut the grass and I file a lawsuit against you, Judge Judy's gonna be like, get out of my face. She didn't promise to cut your grass. Right? But if you follow through, you made that contract binding on me because I did promise.
Now, what if they said, okay, I'll be here on Monday. I'll see you then.
Then that became what? I love that question.
Bilateral, right?
Bilateral. That's exactly right. If the other party said, got it, love it, be here on Monday to cut the grass, have they now promised to cut the grass?
You have an event on Tuesday and they're going to miss it now because you didn't cut the grass like you promised you would.
That's exactly right. And could Taj now be sued for not coming on Monday and cutting the grass?
Absolutely.
That's bilateral. How do we all feel about that? Those were two great questions back to back. Does that help kind of cement in your brain the difference between unilateral and bilateral?
Yeah, I was just kind of Googling some examples of unilateral agreements, and one that kind of like, I kind of thought of another one just off the boat was, which is kind of funny given the example that they put here on the interwebs. I'm going to post it in the chat. But it made me think, like, if you have kids, you could give them a unilateral agreement saying, if you wash the dishes, I'll give you 50 or $10. Like,
I was
they don't have to.
Wash your dishes.
How about ice cream?
$10 for washing the dishes.
Right.
You better get them dishes done.
Exactly. You're going to have a line out the door for that.
But for real though, like, even if you were going to say, like, I'll give you ice cream if you wash the dishes.
Unilateral contract. That's exactly right. The kid.
And then they have the choice.
And here's the thing. If you think of it this way, because I love this example actually, because if you think of it logically, it actually makes sense. If you go in the other room and you tell your kid, listen, I'll buy you ice cream this afternoon if you clean the kitchen. And the kid says, gotcha.
Or I'll take you to the pool.
Can you get mad at the kid if they don't clean up that afternoon?
They won't do it.
Because they never said they would clean up. You told them you would do something for them if they cleaned up. Now, here's the thing. If they clean up and you don't take them for ice cream, do they have the right to get mad at you?
Yes.
Yes. Mama, you told me we're going for ice cream. I clean the whole house. And yes, that's a perfect example of a unilateral promise. It's one-sided. Only one has made a promise to the other. But now, if you go in the other room and say, I tell you what, I will get you ice cream this afternoon if you come in here and help me wash the dishes. And the kid says, that sounds good. I'll be right there. What kind of promise is that?
Bilateral.
That's bilateral.
Another example, just because it made me think of my grandpa, who was my best friend, but he had told me that he would take me and my cousin to the pool later that evening if we stopped calling him and asking him how long it was going to be before he got home. We didn't uphold our end to that agreement, so we didn't get to go to the pool.
But there you go. There was some inducement about going to the pool that you didn't live up to.
Yes.
There you go. There you go. How we all feel with that? Because that's an important distinction, and people do really struggle sometimes with unilateral versus bilateral. But once you get it, you got it locked, is what I find. You know, and so hopefully you got that nailed down. This enforceable word is a magic word because enforceability means a court of law would compel, would force one party or the other to act. Now, I don't want you to think of this as an all or nothing thing, and that's one of the dangers of contract law that people fall into. They think a contract is either enforceable or unenforceable. What I want you to understand is those are polar opposite extremes, right? A contract is fully enforceable if every promise in that contract must be lived up to. Everybody with me on that?
Yes.
A contract is unenforceable if none of the contract promises have to be followed. But guess what, folks? There's steps along the way. Do you think we could we have a partially enforceable contract? Do you think we could have a contract that ends up in court and the judge says, well, these promises have to be followed, but these don't for some reason? Could we have a partially enforceable contract?
Yes.
We could. So don't be so all or nothing when you start to think about these contract statuses.
And that's something I was just kind of thinking about. And there must be multiple factors that go into determining whether a contract is enforceable.
Absolutely. So let's talk about validity. A valid contract is one that is enforceable on both parties. Meaning every single promise made in that contract is subject to a judge saying, you got to do this, you promised. So let's say that Yasser and Summer have a valid contract between the two of them. I'm not even going to tell you what a contract's for, but they have a valid contract. Everybody with me?
Mm-hmm.
Yes.
They have a valid bilateral contract. So here's what we know, just based on that. How many of them made promises? Did just one make promise or did both make promises?
Both.
They both made promises and that contract is valid, meaning every promise in it is enforceable. Everybody with me on that?
Yeah.
Practical question. Can Summer sue Yasser if he does not comply?
Yes.
Yes.
Yes. And would she win?
Yes.
Yes.
Yes, because the judge would say you have a valid and enforceable agreement, ma'am. You win. Could Yasser sue Summer if she doesn't comply?
Yeah.
Yes.
Yeah.
Yes. And the judge would say you have a valid and enforceable agreement. You win. They both hold each other accountable. Does that make sense for everybody?
Mhm.
Yes.
So a valid contract is one where every single promise is still in force. There were multiple promises made and all of them are enforced. Does that make sense for everybody?
Mhm.
Yes.
Okay. So simple things. I don't want you to lose sight of this. Let's say that Summer is the seller of a house and Yasser is the buyer. And they've agreed that Yasser is going to pay Summer a $25,000 deposit and a $250,000 total purchase price. So Yasser's not only made one promise, but what?
Two.
Two. $25,000 deposit, $250,000 purchase price. Would Yasser be in violation of the agreement if he never pays the deposit?
Yes.
Yes. So could Summer sue him for payment of the deposit?
Mhm.
Yes.
Absolutely. Okay. So let's say we've gotten through all of that. Let's say that didn't happen and Summer sues him and the court says, you got to pay this deposit. So Yasser's like, fine, here's my check for $25,000. Well, we're going to keep moving forward, folks. The thing doesn't go away just because we had to force somebody to comply. Do we still have a valid and enforceable contract?
Yes.
Mhm.
Yes.
We do. So we've moved along. Yasser does some inspections. He finds out that there's some wood rot on the roof, needs to be replaced. And he gets Summer to agree. They go back and they add to their agreement that Summer's going to replace the rotten wood before we close. Everybody with me?
Mhm.
Yes.
We get to the day of closing and Summer hasn't done the repair. Maybe she gives us some reason she can't get a contractor out there. I tried, whatever, it was too expensive, whatever her excuse is, she hasn't replaced the wood. Can Yasser now turn around and sue Summer under the exact same contract that she sued him under first?
Yes.
Yes.
Yes, because now she's the one out of line. Now, this would talk about a disaster transaction. If you actually had two lawsuits from the same transaction, it's time to retire. Get out of the business if that ever happens. I hope it never does, but it could. Is everybody with me on that?
Yep.
Okay?
Yes.
Because both of them are able to hold each other accountable. Is everybody with me on that?
Mhm.
Yes.
Okay.
Can I ask a question?
Yeah.
So if in that instance, they do go to court for one or the other, does that mean that the entire transaction stops?
It depends on what they ask the judge for and what the judge decides.
But do they do a Liz Pendens before they do that?
Well, they might. We're going to talk about that in a minute. We're
Okay.
going to get to a Lee Pendens. Yeah.
Sorry.
But no, you're fine. You're fine. But the key here is, let's say we'll go back to Summer suing first. if she sues and she asks the court, I still want him to buy my house. I want him to do what he promised to do. The court could force him to do that. Does that make sense for everybody?
Mm-hmm.
And in that case, the contract wouldn't be over. It would be pay your deposit and keep moving it along, move it along. That's what the court's going to say. But she might also say to the court, listen, he's already breached his contract one time. I don't want you to make him move it along. I just want you to make him pay me my deposit and go the heck away. Could the court potentially consider that as a resolution too? Just,
Yes.
we're going to make him pay, but then we're going to terminate the agreement. That's where it becomes up to the judge at that point in time. Everybody with me on that?
Yeah.
Okay. So validity is the highest level we can have for a contract, because validity, when you say an agreement is valid, you literally mean that every word of the agreement matters, that every promise made by both parties is going to be enforced by a court of law, that either party steps out of line, they're running the risk of being sued at any time. That's valid. Not every contract is going to be valid, though, unfortunately. And so hopefully you see where we're headed here. Are we going uphill from here, or are we going downhill?
Down.
Downhill.
We're going downhill. Now, remember, what's all the way at the bottom of the hill before we get down? What did we say was the worst contract status that there could be?
And no contract?
Non-enforceable.
Unenforceable.
Unenforceable.
The worst contract status you could have is unenforceable, because that means a judge would literally say, what if you went in front of them?
I can't.
There's no contract.
I can't do a thing with this. Get out of my face. You're wasting my time. This is what? It's unenforceable. So if valid is the gold standard, then the hot garbage is on the other end of the spectrum is unenforceable. Does everybody see what that?
Mm-hmm.
So what we're doing is starting this progression down toward unenforceable, but we're not headed straight for unenforceable. There's a stop along the way. That stop is called voidable. A contract is voidable when it has some enforceable promises, but some that are what?
Unenforceable.
Unenforceable. That's exactly right. When a contract is declared voidable, it means that the contract, the agreement, has some promises that are enforceable and some promises that are not enforceable. So here's what that means, basically. One party is going to be bound to their promises. The other party, for some reason, and there's various reasons which we're going to talk about, is not going to be held responsible to their promises. And we'll say that again. When a contract is declared voidable, first thing you need to understand, does a voidable contract have legal weight?
Yes. Yes.
Yes, because if it had no legal weight, we would call it what?
Unenforceable.
Unenforceable. We're not at the hot garbage stage yet, folks. We're just, it stinks a little bit. Okay. A voidable contract is one where there is still legal weight, but only on one side. You've got two parties, two sets of people who made promises, but only one of them is going to be held responsible for those promises for one reason or another. Look at the picture you see on the screen right here. This is an example of and it's not the only example, but it is an example of a voidable contract being formed. If these are the two parties, if this is party number one and this is party number two to this agreement right here, and I would point out he is signing with crayon. If that's party number one and that's party number two to that agreement, do you think a judge, if this agreement landed in front of them, would say this is a fully enforceable, valid contract?
No, because
he's a kid.
Because he's a child, right? We all see that connection. Does that make sense for everybody?
Mm-hmm.
Here's where you're going to make the mistake, though. We all see the connection that this cannot stand. Does everybody agree that this cannot stand? We are not going to force this child to follow through with their promises. Everybody agree with that?
Yes.
Yes.
Here's where you're going to have the problem, because you think in too much extremes. It's not going to destroy the validity of the entire agreement. The only promises that are going to be unenforceable are the ones made by party number 2 here. Everything promised in that agreement by Lester the molester right here
Wow.
is going to be enforceable because he is a what?
An adult.
An adult.
An adult.
And so here's my question, and this is what is the key to wrapping your brain around a voidable contract. Can one of these parties sue the other and get relief from a court of law?
Yes.
Yes.
Can one of these parties sue the other and force the other to go through with their promises?
Yeah.
Yes.
Yes.
Which one can sue?
Party 2.
Number 2.
Party number 2 has the legal right to sue party number 1. If party number 1 goes, that was just a joke, you signed it in crayon, that is not going to matter in a court of law, because the court of law is going to say, it might have been a joke for him, but it was not a joke for you, my friend. You are an adult. You knew what you were signing. You're going to be held responsible for what you promised in this agreement. Is that starting to click into place for everybody?
Mhm.
And so what ends up happening in this voidable agreement is that the court basically says, okay, find the promises made by number 2. They don't matter. Find the promises made by number 1. They matter. Another way of saying that is, could party number 2 just walk away at any time with no repercussions?
Yep.
Yes.
So party number 2 is not bound, but party number 1 is bound. That is a contract so with the example we just used is one that starts as voidable from the very beginning. I do want to point out though, and we're going to elaborate on this further, a contract could start as valid, but change to voidable. We're going to talk a little bit more about that, but sometimes contracts start as voidable. This is one that clearly starts as voidable. Does this make sense for everybody? And just as an aside, could this contract, even this one, become valid at some point in time?
Okay, yeah.
Yes.
Yes, if we wait. If we wait long enough, is the problem that this contract has with validity going to resolve itself?
Yeah, it's about to get older.
Yes.
12 years.
At some point in time, because we don't know what this contract is or how long the term of this contract is, at some point in time, is party number 2 going to reach the age of contractual obligation?
Yes.
Yes. And folks, if they are still under that contract at the time they reach the age of 18, this contract will no longer be voidable. Now every promise that is made by both parties will be enforced. And guess what the contract would become at that point?
Valid.
It would be a valid contract. So these statuses can change. Does that make sense for everybody? So the child has the right to get out, but he better get out before he turns what? 18. Because after that, he's bound. Now, Jonas asked a question over there. Are all voidable contracts unilateral? And the answer is no, shockingly. As a matter of fact, Jonas, all voidable contracts are bilateral, because bilateral means both parties made what? Promises. A unilateral contract never worries about being voidable, because in a unilateral contract, there would never be promises made by number 2. Does that make sense for everybody? A unilateral contract is one where number 2 never made any promises at all. A voidable contract is one where number 2 made promises, but they're not going to be enforceable promises. That's a great question. Really good question. Okay. So just like this voidable contract could change to valid, a valid contract could change to voidable at some times. Sometimes contracts start as valid. So we'll go back to an example that we used, well, we'll just start a new one. Let's say Aaron is selling a house to Elizabeth. Okay. Aaron is selling a house to Elizabeth, and they've agreed on a purchase price. They've agreed on a deposit amount. They've agreed on the closing date. They've also agreed that Aaron will replace the roof prior to closing. We get to the date of closing. Everybody with me so far? The roof's not replaced. Does Elizabeth, the buyer, have rights in that bilateral valid contract?
Yes.
Yes.
She can sue, correct?
Yeah.
Yes.
She also has another right, and this one is the harder one to wrap your brain around. Elizabeth can say, we no longer have a valid contract.
Right, because you
I'm
didn't perform.
declaring that our contract is what?
Void.
Not void. Not void.
Voidable.
Valid.
Voidable.
Not valid?
Voidable.
Voidable.
Elizabeth doesn't want to declare the contract is void. She still wants Aaron to be bound to her promises. What she wants is for her, Elizabeth, the buyer, to no longer be bound. Here's what, listen, folks, this is the rational thing you would say. What is Elizabeth going to say on the day of closing? You didn't replace the roof, so I'm not going to what?
Close.
I'm not going to close. Isn't she declaring that my promises don't matter because you breached your promises?
Yep.
Yes.
And so essentially what Elizabeth is declaring is that our contract is now voidable. It is voidable at my option because you have harmed me by breaking your promises. And here's the interesting thing. If Aaron filed a lawsuit at that moment against Elizabeth, everybody with me so far? So Elizabeth's the buyer, Aaron's the seller. Aaron promised to replace the roof. Elizabeth said, I'm not closing because you didn't replace the roof. And Aaron sues Elizabeth. Guess what the judge would say?
A win?
Stop my time.
No.
Replace the roof.
The judge is going to say, this is a voidable contract.
Okay.
The buyer is not obligated to follow their promises because even though it started as a valid contract, the minute the seller breached their promises, they released the buyer from all of their promises. So
Ooh, okay.
promises made by the buyer are no longer enforceable. Therefore, the contract is voidable.
I'm just giggling how Aaron went all in and said, I win.
Yeah.
I was like, "Ooh, I was
Exactly.
invested."
Does that make sense though? The judge is essentially going to say, Elizabeth didn't do anything wrong here. I can't force Elizabeth to purchase this property because the promise she was made of getting a roof replacement didn't happen. So I'm not going to hold her responsible for her promise to purchase the property. Does that make sense for everybody?
Yes.
Yes.
Everybody good with that? But now to show you how much contract statuses can change, can Aaron make that back into a valid contract quick, fast, and in a hurry if she chooses to?
Yes.
Yes.
By doing what?
Replacing the roof.
By replacing the roof. As soon as she puts herself back in compliance, the contract, the argument of Elizabeth that you didn't follow your promise is now gone. Does that make sense for everybody?
Is there still a time limit on that?
Well, that's going to depend on what the contract itself says. That's where you have to read the verbiage of the contract. Right now, we're just talking about the concepts of validity and voidability. You know, presumably a good, well-written contract would say that these have to be resolved within a certain amount of time. Otherwise, the contract is terminated. But the idea here is Elizabeth has an argument. I'm not buying the property because you didn't replace the roof. Well, what if Aaron replaces the roof and Elizabeth still won't close? And now Aaron files her lawsuit, which now win the same lawsuit that she would have lost the week before.
Yep, she wins.
Will. Because now the judge is going to say, excuse me, ma'am, you had an argument last week, but that argument no longer stands today. She replaced the roof.
Is it considered replacing the roof if they do a holdback for the stuff to be done
Well,
later?
right, they might come to some other agreement. They might come to some other agreement, but that would be an additional agreement. Okay. Is everybody understanding the idea how a breach takes us away from validity? There's no such thing as a breached valid contract. If it was breached, it got downgraded from valid to what?
Invalid.
Not invalid. There's no such thing as invalid.
Voidable.
Right? These words have very specific meaning. What's the downgrade from valid is voidable.
So when they're in voidable status, let's say they say it's 30 days till you fix it. She fixes it, then we're good. But if she doesn't, then it's void.
Well, no, don't use that last word. I didn't say
Okay.
that. You shouldn't either. Void has a very specific meaning, and that's not what void means.
Okay.
Okay. It's terminated is what it is.
Okay.
It's over. Void is not terminated. They don't mean the same thing. Okay.
So you did say, Travis, that being breached is what turns the contract into.
I said a breach is one example of something that can change a contract from valid to voidable. There are lots of examples of how contracts could start as voidable. Look at the picture over there again. That's not a contract that began as valid. That contract began as what?
Voidable.
Voidable. So a contract can be voidable from the very outset if it has a fundamental flaw, like one of the parties doesn't know what they're doing. That's a fundamental flaw. That's a voidable contract. The party who does know what they're doing is going to be bound. The party who doesn't know what they're doing is not going to be bound. That's voidable. But you could start as valid and have one party breach, and you get a downgrade from valid to what?
Voidable.
Voidable.
And then you can go back to valid, right?
And then you can go back to valid if people get back in line. Just like this one that starts as voidable could go to valid. If we wait long enough, he's eventually going to be what?
18. Yeah.
If they stay under contract for the next 15 years and then number two tries to get out, what's the judge going to say? Well, my friend, you've been 18 now for like 6 years. You understood the implications of staying in this contract that whole time. You don't get the excuse that you were 11 when you signed it the first time. That's not an excuse, because you could have decided at any time up prior to you becoming 18 that this was not for you. The minute you were 18 and you stayed in this contract, you agreed that you wanted to be bound by this contract. This is a valid contract. Does that make sense for everybody, how it would change back?
Dogs are now.
Yes.
Right? But the idea here is voidability is a problem with the contract. You can always resolve problems. And if the problem is resolved,
Folks are taking a nap.
we go back to being valid, or we go to being valid even if we never work. Okay. You got to grasp that these can change. Is that all clicking into place? Okay. Basically, if everybody knows what they agreed to and everybody's in line, what's our contract status? If everybody knows what they agreed
Everything's
to,
valid.
everybody's in line doing what they're supposed to do, it's valid. If somebody doesn't know what they agreed to, it's what?
Voidable.
If everybody knew what they agreed to, but one person's out of line, it's also what? Voidable. Is everybody good with that?
Yes.
If everybody knew what they agreed to, one person got out of line, but that person got back in line, what's our status?
Valid.
Valid. We started valid, we went to voidable, we went back to what? Valid. See how it can shift gears and change? Right? What if we started with one person who didn't know what they were doing, but eventually there came a time when they did know what they were doing? What's our status?
Valid.
Valid. We started as voidable, and we upgraded to valid. They can go either way.
Awesome.
Feeling pretty good about that?
Huh?
Yes.
Okay. It's all about what happens after the agreement, as to what, and don't think of it as some locked in status, right? The other people who don't know what they're doing, in addition to minors, a good example would be intoxicated persons, people who are intoxicated at the time. But here's the thing now, here's what I want you to understand. And this is where that whole changing dynamic becomes important. Let's say you present an offer to a seller and they are knee walking drunk and they accept the offer. Are we valid or voidable?
Voidable.
Voidable. It's been 2 weeks later. since they accepted the offer. And now they want to get out. Are they going to be able to get out?
No.
No.
Yeah.
No.
No.
Because any court of law
intoxicated.
any court of law is going to say the minute you sobered up, you should have realized you didn't want to do this. And that was the time for you to say, I want out of this. You don't get permanent carte blanche to get out of this because you messed up one time. I mean, you'd pretty much have to go to the court and say, Your Honor, not only was I knee walking drunk when I signed this thing, I am a raging alcoholic and I have been perpetually drunk since then. And I have not had one moment of sanity since then. So I still should be able to get out of this thing. Because the minute you have that moment of clarity, the court says you continued on. So you must, now we have a what kind of contract?
Valid.
Valid contract. Is that starting to click into place for everybody?
Yes.
The courts want to enforce these agreements. So basically, if you want to exercise these rights to get out, you better exercise them while you have the right to get out. You better, and so somebody who's intoxicated when they sign an agreement, basically when they sober up, it's sort of like that moment. I mean, we've all had that moment where you sober up the next day and you're like, oh my God, what did I do last night? Right. And if what you did last night is sign a purchase agreement, you better call and terminate that thing first thing. Be like, listen, I just woke up, my head's about to bust wide open. I had no idea I was signing this thing last night. I thought it was the tab at the bar. I did not know this was an offer on my house. Terminating. But if you wait 2 weeks, the judge is going to say, no, you're bound. Everybody okay with that?
Yes.
Good. And then now we finally slid all the way down the mountain to unenforceability. Unenforceability is a contract that has no legal status, no legal weight for either party. There might be 20 promises in that agreement. What's the judge going to do with all of them?
Throw them out.
All gone. No promises. Now, there are promises that were made, but none of them are going to be enforced. Does that make sense for everybody? There were promises made, but none of them are going to be enforced. Neither party is obligated to perform at all. We say those contracts are unenforceable. And that could have started as valid, by the way. So go back to our contract between Aaron and Elizabeth. If you go back to our contract between Aaron and Elizabeth, we had a valid contract in the beginning. Aaron refused to replace the roof. We went from valid, we downgraded to what? Voidable. Elizabeth says, well, if you ain't replacing the roof, I sure as hell ain't closing. Has Elizabeth also breached the contract at that point in time?
Yeah.
Yes.
We slid one more step down the ladder.
Right.
Now it's
unenforceable. Now it's
unenforceable. When you have a breach when you have both parties breach, a court's going to look at it and go, what do you want me to do with this? Neither one of you follows through on what you say. Just get out of my face. If you had two minors who signed a contract, what would it be?
Unenforceable.
If you have a drunk person and a minor sign a contract, that sounds like the start to a bad joke. But if you have a child and a drunk person sign a contract together, what's the status?
Unenforceable.
Could that contract become valid?
Yes.
Yes. If you wait long enough for the drunk to sober up and the child to become an adult, that will become a what?
Valid.
Valid contract. See, I love it when you start to see how those gears can change, right? Based on it's all about the current moment when you talk about contract status. Okay. We all good with that so far?
Yeah.
Good. There is one other word, and I'm going to have to take my break here in just a second because I just saw the van pull up for the vet. But there's one other word I want to talk about before we take that break. And it is the word void, which you heard me say earlier that void is very different. Void contracts are contracts that never were. They were never an agreement at all because they're illegal. A void contract is not a contract with a minor. That's a voidable contract. A void contract is a contract where the thing that was promised in the agreement is actually illegal. If Patty promises in writing to sell Hilda a pound of marijuana, that's a void contract.
Okay.
And that's very different than voidable. And on that note, let's take a break, folks.
So that's a North Carolina example, right?
That is. Let's take 10 minutes, okay?
Okay.
All right.
There's no relationship at all between a void agreement and a valid agreement, or even a void agreement and a voidable agreement, even though the names sound similar. Because the problem with a void agreement is not that the parties are wrong, or one of the parties doesn't know what's going on, or one of the parties was drunk, or one of the parties was a minor, or one of the parties breached the contract. That's not the problem is not with the parties when you have a void contract. When you have a void contract, the problem is with the agreement itself. You know, I use the drug deal as a really wild example, but here's what you might get on the test. So tune this in for a second, because you need to pay attention here, right? On the test, you might see something that says, Claudia has signed a lease on a property that's in an area zoned exclusively for residential use. And the lease promises that she can use the property as a dance studio. We'll say that again. Claudia has signed a 2-year lease on a property located in an area zoned exclusively for residential use. And the lease promises that she can use the property as a dance studio. Folks, that's an example of a void contract. The reason it's void is it doesn't matter who Claudia is, or what her mental condition is, or whether she's an adult or whether she's a minor. It doesn't matter about if the landlord is mentally capable, or if they're an adult, or if they're a minor. It doesn't matter if either one of them has breached their agreement, because if they followed the agreement, they would be breaking the what?
Law.
The law.
No.
Because if the property is zoned
Illegal.
only for residential use, it would be illegal to use it for a dance studio. Does that make sense for everybody?
Yes.
So any agreement where if the judge says, you promised to do this, substitute, you promised to break the law. Now go break the law. Do you think a judge is ever going to say that?
No, never.
No, that's a void agreement. That's a void agreement. How do we all feel about that? Are we good on the different, that void is just very dramatically different than the other contract statuses?
Mhm.
Okay,
Yes.
good, very good. So when we talk about these agreements a little bit further, now we're leaving, this is again, an additional layer that we're adding on. So let's talk about the layers. It's almost like making a fancy cake here. We started with whether the contract was express or implied. And we said that has to do with whether or not it's been clearly laid out, either verbally or in writing. That's an express contract. An implied contract is one that is just based on what people do, not what they say, but what they do.
Actions.
Their actions, exactly. Then we layered on, okay, is that contract, now that we know if it's express or implied, is it bilateral or unilateral? That it's not a different thing, it's an additional thing. Does that make sense for everybody? Okay, so it might be an express bilateral contract or an implied unilateral contract. It's an additional layer of definition. So we laid on, is it bilateral or unilateral? Then we layered on a whole nother layer. Okay, now that we know if it's express or implied, now that we know if it's bilateral or unilateral, we need to know, is it valid, voidable, or unenforceable? Does that make sense for everybody? Okay. It's time for layer number 4. That's a lot of detail we've given this contract, right? So far, let me give you an example. Jordana agrees to sell her house to Grant, and they've agreed on a purchase price of $250,000. They've agreed on a closing date of April 26th. Grant has promised he'll purchase the property April 26th for $200,000. Jordana's agreed she'll sell. And they've signed it. First of all, is that an express or implied agreement?
Express.
Express, because they put it down and they signed it, right? That's express. Is that a bilateral or unilateral agreement?
Bilateral.
Bilateral.
That's a bilateral agreement. So far, it's an express bilateral agreement. Does that make sense for everybody?
Mhm.
Is it valid, voidable, or unenforceable?
Valid.
Valid. So now it's an express, bilateral, valid agreement. You see how we're just layering these on here?
Yeah.
Right? I don't want you to think of these as being like, oh, that's different than the other things. It's an additional layer of information. So we would know a bunch of things about that contract by saying it's express, it's bilateral, and it's valid. Well, now is the final layer that we're going to put on these contracts. Layer number 4, and it's the last one that we're going to talk about here. Is the contract executory or is it executed? Has the contract been executed or is the contract executory? Now, keep in mind, this is not different than valid, void, voidable. This is in addition to. So that agreement between, and I'm going to tell you what it is, and then we'll talk about why. That agreement between Grant and Jordana is express because it's in writing, right? It is bilateral because they both made promises, correct?
Yeah.
It is valid because they're both adults, they're both sane, they're both sober, they both know what they're agreeing to. And it is executory. Here's how I know it's executory, not executed. An executed contract is one that is completely finished. It is closed. And notice I said they had gone under contract with Jordana. Jordana, is it a soft A or a long A? I'm sorry. Is it Jordana?
It does either or. I actually like it when you guys say it down here in the South.
Okay.
Jordana sounds fancier.
Jordana. Okay, well then that's what we'll go with.
I love it.
We'll go with. Just make sure you hold your pinky up, and then we'll
Okay,
call
don't
you
you
Jordana.
worry, I got
there we
that
go.
covered.
There you go.
Well, in that case, I'm Grant.
You're Grant. Okay,
Y'all
so
are too funny.
we have this contract between Grant and Jordana. That does sound. It either sounds like I'm hoity-toity or y'all are. So I don't know which it is.
We're going
But
with it.
they have agreed, but they haven't yet what?
Executed.
Closed, executed,
Okay.
exactly. So they have an express, bilateral, valid, and executory agreement. Does that make sense for everybody?
Yes.
Okay. And Grant, that is very apropos for you because that would definitely be Moira's pronunciation of your name. You know, Grant would be the Moira pronunciation. I believe that falls under the same category as enchilada.
There you go.
And Grant is actually my last name, so Jordana Grant.
Yeah. Oh, there you go. So she's got the double whammy there. See how that works?
God.
But an executed contract is one that is fully closed. So when they're under contract, the term is executory. Does that make sense for everybody? So if you see a house and the sign out front says pending, they have a contract, but is it an executory contract or is it an executed contract?
Executory.
Executory. Once they go to the closing and they're done and the deed's been recorded, that contract has been executed. That makes sense for everybody?
Yes.
And that's that final layer that we put on of these contract statuses. So that is again an express, bilateral, valid, executory agreement. And then when they close, it'll be an express, bilateral, valid, executed agreement. Okay. How are we with that? And it is a lot. It is a lot to layer on, and it's especially your mind is not used to thinking about contracts in that frame. In order for a contract to be considered valid, now remember, valid has a very specific definition. Valid means binding on all parties, right? In order for a contract to be considered valid, there are some what we call essential elements. That's a fancy way of saying if you don't have these things, it ain't a valid contract. If any of these things are missing, you don't have a valid contract. You might have a voidable contract, you might have an unenforceable contract, you might even have a void contract, but if you're missing any of these things that we're about to talk about, your contract cannot possibly be valid, okay? The first of those things is it must be voluntary. We need a meeting of the minds. We need, you'll see this phrase a lot: mutual agreement, mutual assent, mutual acceptance. In other words, we need to be able to clearly show, for a court of law to say this contract is valid, we need to be able to clearly show that both parties agreed to the exact same terms and conditions. So, and I think that was Taj's question earlier. You know, what if when we were talking about making changes to a contract, Taj, you remember you asked that question about, well, what if the buyer marks through 5 days and puts 10 days, but the seller didn't sign that? I said, well, then that's not going to be a valid agreement, right?
Right.
And that's because it's not clear that both parties agreed to the 10 days. So what we need to first show, if we're going to try to prove to a judge, hey, this is a valid agreement, we need to show that both parties agree. There's a very simple, straightforward way to show that. What do you think is the best possible proof that you couldn't? It's not the only, but it's the best possible proof that both parties agreed to the same terms and conditions.
Initial.
How about signing or initialing the exact same version of the contract?
Yeah.
Wouldn't it be nice if we had signatures, everybody's signatures on the exact same document? If everybody signed the exact same document, isn't that the best possible proof we could show that they all agree?
Yeah, here to pick up an order for Sean.
So are we good on this idea of mutual agreement? I hope it's a good order.
I know, right? That was too good.
The mutual agreement cannot be reached if you have any of the following things present. These things would override that mutual agreement. If there's a mistake, like as an example, if the two parties agreed to a contract, but you have the wrong legal description on it, what do you think a court's going to say that's a valid contract? Or are they going to say, no, you don't have an agreement at all because you got this is not the correct property?
Correct.
Right? So mistake would prevent us from having a valid contract. Fraud or misrepresentation. If either of the parties engages in fraud, it doesn't matter if they both agreed. If one of them was induced to agree based on fraud, if one has committed fraud, that would prevent us from having a valid contract. And then you get into the ones where somebody is forced. I think of the stuff on this slide, these are the two you're likely to see a test question about, and they're going to be both on the same test question if it shows up, because they're going to want you to differentiate the two. These are two different ways of being forced. You can be forced with two different types of threats. You can be forced with a physical threat. Somebody is physically restraining the person agreeing to the contract. Somebody is holding the person at gunpoint, at knife point. Somebody is threatening to, like, if you don't sign this contract, I'm going to dump you out in the middle of the desert and forget you're out there. You know, if you don't sign this contract, mama, I'm not going to go buy your medicine from the pharmacy anymore, and you can't drive anymore. So good luck. That is, can we all agree that all those are the threat of physical harm to somebody? Yes. I mean, you know, it's horrible to say, but we actually had a court case about this in North Carolina last year. There was a guy in Eastern North Carolina who actually threatened his mother with not bringing her food if she didn't agree to sell the family farm. She was dependent on him bringing food to her, and he wanted to sell and she didn't. And he basically said, well, you know, if you don't love me enough to take my advice to sell the farm, I don't love you enough to bring you food. And so she signed the contract. Well, a court declared that contract was not valid, that she was under duress. That's the terminology for that. Does that make sense for everybody? Okay. Any threat of physical harm is duress. The threat of emotional harm or emotional influence is called undue influence. So an example of undue influence might be like, well, if you don't agree to sell, we're going to get a divorce. I'm filing for divorce. Either you agree to sell the house or we're getting a divorce. Well, that's not physically harmful, but it is emotionally harmful, right? You're using that emotional connection to this person to entice them into agreeing to the contract. So either one of those would prevent us from having a valid contract. Are we all good on those terms and the difference?
Yes.
Okay, good. Good. The second essential element of a valid contract, or the second thing that must be present in order to have a valid contract, the contract has to include something called consideration. Now, there's a reason this picture is on the slide, and I didn't think about this. Did anybody have a problem printing this based on this picture? Or is this one okay? It was okay.
No, mine's
I'm
good.
fine.
You have to be
Mine's
real.
okay.
You have to be real careful of how you put pictures of real money in things like this, because the software is designed to stop people from trying to counterfeit. Usually if it's rolled up or there's lines across it or stuff, it'll let it go. But don't try to put like $100 bill on something in one of these slides. It'll lock their printer up, you know.
We'll let you know if anybody shows up.
I didn't know that.
Oh yeah. And don't you dare put a piece of currency on one of these on a new copier, like the new fancy copiers, this, you know, especially the really good color ones. It will brick that machine and it will never function again. That's a feature that's built into the machines. And in fact, the ones in our office are such good quality that if you were to put like $100 bill on the glass of one of them and hit print, not only would it brick the machine, but it would immediately contact the Secret Service and turn you in for trying to counterfeit money. The machine is programmed to do that.
No wonder they came last year.
Exactly. No wonder they showed up, right?
What are you doing, Seth?
Tried this with my own printer and it worked fine on mine, because I tried to crop the picture out, you know, like where there was no serial number showing, and so there was no, you know, and so I'm glad to hear nobody had a problem printing. But there's a reason that money's in this picture, and it's the reason I wanted a picture of money in here, because in contracts, consideration is almost always monetary. Consideration is the promise of the exchange of value. In North Carolina, folks, you cannot have a valid contract unless there is the promise that something of value will be exchanged between the two parties. So let me give you an example of what would not be a valid contract in North Carolina. Sierra signs a contract with Jonas promising to give him the real estate located at 114 Heidinger Drive. I don't care how much they write it down, how much they sign it. They could get it notarized. They could go do it, sign it right at the courthouse. That is not a valid and enforceable promise in the state of North Carolina, because I said Sierra promised to do what with the property?
Give it to him.
To give it to him. There is no consideration in that agreement. Jonas is not providing anything of value in exchange for the property. Does that make sense for everybody?
Yeah, so how do they do that?
So here, well, to make it binding, now they can transfer it without paying for it. You can transfer it as a gift, but you couldn't have a contract promising to transfer it that was enforceable. But could Jonas say, oh no, Sierra, I insist, I have to pay you at least $1 for that property. Let's write it up that you will sell me the property for $1. Would that make this a valid promise in North Carolina?
Yes.
Yes, because now you have promised to exchange something of value. That's why, if you all will remember back, way back when, in Unit 2, when I showed you the progression of deeds from my house, do you all remember that? You all remember the quitclaim deed when Sandra Bolden and her husband got divorced? It says on there for the sum of $10.
Oh.
And the reason that's there is not because they actually paid $10, but in case there was ever any question that this was a valid agreement between these two, you've got legal consideration there. Does that make sense why that shows up like that?
Yes.
So anytime you ever go to an attorney and you're trying to negotiate a settlement on something, they say, well, we got to put some dollar amount in there. That's also why if you ever go, and I shouldn't tell you this because you shouldn't do this, but you know, I'm gonna tell you when. If you ever want to like write your children out of your will, don't just write them out of your will, because the law will assume you forgot them. Leave them $1. If you leave them $1, the law knows, oh yeah, we see, we got you. We got you, Patty. We see what you're trying to do. We understood. Okay? It clarifies the intent. But here's the idea of the law here. If you completely leave out any promise of compensation, the law assumes you meant to have compensation in there and you forgot it. So they can't enforce the agreement without it being there. Does that make sense for everybody? Whereas if you just put something in there, it's clear, okay, you did mean for it to be this amount. Okay, so a valid contract needs the promise of consideration. In a sales contract, purchase price, that's consideration. In a lease, rent. So let me ask you this question. If I lease property to somebody and don't charge them rent, if the written lease says no rent, do we actually have a valid lease?
No.
No, we don't. We don't.
It's $1.
Yes, Elizabeth, this is North Carolina specific. Yeah. Well, yes and no. It will be tested this way on the national section because the way we do it in North Carolina is the most common way. Interestingly enough, different states have different interpretations of what consideration can be. South Carolina has my favorite one. They have a lot of interesting laws down there, but they have one of my favorite ones. You can use the phrase love and affection as consideration in South Carolina. So you could actually write a contract that says, in consideration of the love and affection between the two of these parties, they promise to do this. And a South Carolina court would say that's consideration. A North Carolina court would not. We would be like, you can love and consider them all you want to, but you need some money in here.
That sounds like something you would see in Vegas.
Right. And it doesn't have to be money. I'll just point out, it does not have to be money either. You know, it could be, you know, Patty has agreed to exchange 2 goats with Philip for his property located in Lake Gaston, and the goats would be the consideration, you know, because they have value. So anything of value. We already mentioned this earlier, but it bears mentioning again. You cannot have a valid contract if one or both of the parties is not mentally competent and understands what they've agreed to. And so this would include people who are minors under the age of 18. This would include people who are temporarily mentally impaired, like, you know, they are intoxicated. But it would also include people who are having, you know, just mental issues, but they've not been declared mentally incompetent, but maybe at the time they were having, you know, a judge could decide that somebody was having, but these would all be up to a judge to decide. These are not for us to decide. These are just reasons why a judge might say someone was not mentally competent at the time. The judge might say they were, well, I feel they were intoxicated, or I feel they were mentally incompetent when they made that decision. And if a judge decides any of that, then we do not have a valid agreement. Specifically, what kind of agreement do we probably have if a judge decides that one of these parties was not competent at the time they agreed?
Voidable.
Voidable. The only difference there is if someone has been declared permanently mentally incompetent, and it's on the next slide. If someone has been declared permanently mentally competent, then mentally incompetent, then that would be a void contract. The idea there is they can never be held responsible. So somebody who has a permanent mental incapacitation and has been declared so by a court of law. So these would be people who have been like appointed guardians, you know.
Or Alzheimer's.
People with Alzheimer's, people with dementia, you know, anybody who has a point, Britney Spears prior to last week. You know, so if you had gotten,
bad for her.
If you had gotten Britney to sign a contract prior to last week, that contract would be a void contract because she had been declared permanently mentally incapacitated, you know. But if somebody has a temporary mental incapacity, that's voidable.
And are temporary mental capacitations considered diagnoses?
Well, it's up to a judge. That's up to a judge to decide. It's not for us to decide. It's up to a judge. Somebody could go to court and say, Your Honor, I was having a really bad mental episode. I have PTSD, and I was having a really bad mental episode when I signed that, so I didn't know what I was agreeing to. And it would be largely up to the judge to decide, okay, was this person mentally competent? Think about it. You hear that all the time in criminal trials, right? Somebody has been found competent to stand trial. Well, who's ultimately making that decision? A judge, right? And so they may base it on a diagnosis, but they're ultimately it's the judge making the decision. And so if somebody goes to court and challenges a contract and says, I didn't know what I was signing, it's going to be up to the judge largely to declare if they were mentally competent at the time they agreed or not. It's a real good question. Not for us to confirm.
Yes, you said permanently mental incompetence makes the contract void, not voidable.
Correct.
Void.
Permanent mental incapacitation. So somebody who has legally been declared mentally incapacitated and has been appointed a guardian to make all their decisions for them. If they sign a contract, the contract is void. And the idea there is we want to signify this ain't going to ever be a contract because this person literally can't form a contract. That's the difference. So like, as an example, my grandfather who passed away of Alzheimer's, my mom and her sister were his legal guardians from 2004 until he died in 2008. If he had signed a contract, which I would not have put past him, by the way, because he did a lot of things during that time. You know, if somebody had come to the house, he'd have probably signed anything they put in front of him, you know, and so and would have been proud about it too. And been like, yeah, I signed a contract to buy us a house today. I mean, he would have just told you, he wouldn't, you know, and then he wouldn't remember it 30 minutes later, but he would have been very proud of it when he did it, you know. That's a void contract because he had been declared mentally incompetent, permanently mentally incompetent. So that's the difference there. The temporary mental incompetency, like intoxication, is voidable. The idea there is they might sober up at some point. They might come around. They might, you know, or even with like PTSD or those kind of episodes, somebody can have PTSD and have an episode where they don't know what they're agreeing to, but then be fine 95% of the rest of the time, you know, so that person, the contract might be considered voidable. That was probably a longer answer than you wanted, but hopefully it helped. Okay. There must be the promise to perform a legal act, which is what we talked about with void contracts. Void contracts are lacking that promise to perform a legal act. If a contract has promises that are illegal, it is not going to be valid for sure. It's going to be declared a void contract. So that, you know, you can use extreme examples, like if somebody puts a hit out on somebody, that's a void contract. It's an agreement between these two parties, but no judge is going to say, now you promised to kill her, go do it. That's not going to happen in a court of law. And so that's a void contract. But it can happen in real estate, you know, as an example, a void contract in real estate. What if I signed a listing agreement promising not to market the property to people of a certain religion? Can I legally promise not to market the property to people of a certain religion?
No.
No. So that listing agreement would be declared what by the courts?
Void.
Void. Because one of the promises within the agreement is an illegal promise.
But if you're...
I'm so sorry, Elizabeth. I heard the dog barking and I muted you.
Sorry, you got muted.
Me. That wasn't my dog. So if I just lost my thought now. Thank you, Seth.
Dang it.
Come on. No, I do that all the time.
We were talking about what?
Youth does that to you, Elizabeth, when you forget things like that. It's a youth.
I think that's it. And the ADHD has something to do with it too.
Yeah, right. No, we were talking about void contracts, and like, so promising not to market the property to people of a certain religion would be an example of a void listing agreement.
So what I was saying is that if you own the house, right, you could discriminate that way, correct?
If I'm the unlicensed owner of a house, that's one of the exemptions to the Fair Housing Act, right?
Okay.
So the unlicensed owner could choose to discriminate if they wanted to as a FSBO. If they didn't
Okay.
hire a real estate agent as a FSBO, they could choose to discriminate, but they couldn't sign a contract hiring somebody to represent them and that firm promising to discriminate. That would be
Got
a
it.
void. That'd be a void contract. Okay. And that takes us through section 8.1, folks. All right. And that's a lot of material. That's a, you know, when you dive into contracts, I always sort of feel like you dive into the deep end real fast with contracts, because there's a lot of big concepts to wrap your brain around. I do promise to you this, contracts get significantly more interesting. This is not what we've covered thus far is not the most interesting topics throughout the class, but it is important to get that underpinning in place of what a contract really is. So we're going to take a break right there.
And to Trav,